This is Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for tuning in. If you have an immigration problem, please get in touch with me and I'll do my best to help you. Today, rather than just reporting on news, I thought I would do a video on something which is very, very important to most migrants, and that is appeals and what happens during the course of an appeal before the first tier tribunal. This is a very important matter, and one on which I've not done a video before, but thought it was about time to do one. The appeal can be the most important day in a migrant's life in respect of trying to get leave to remain. This is because they will be giving direct evidence with any witnesses to a judge who will make factual findings. If they are believed and have a good case in law, then they are likely to win. If they are disbelieved through bad preparation or just not telling the truth, or the background evidence is bad and the matter is dismissed before the first tier judge, it can be very, very hard for an individual to win any subsequent application. It is therefore vital that any appeal is properly prepared and the witnesses appellant know what to expect. I will be doing a video on what you can do to give your appeal the best chance to succeed later. My video today will be addressing what goes on in the first tier tribunal hearing and what you can expect for it. It is understandable that attending court can be intimidating and stressful for people attending court for the first time in their lives. So if you have an upcoming appeal at the first tier tribunal, and if this worries you in any way or you've just got some general concerns, then this is the video for you. Firstly, who will be in the courtroom? There will normally be at least 4 people in the courtroom at an appeal hearing. That would include you, the most important person, your representative, the Home Office's representative, and the judge. Sometimes you can have viewers because the courts are open, but that doesn't tend to happen. The court's clerk or judge's assistant may also be present to assist the judge with administration and making sure that the hearing runs smoothly. But they usually leave the courtroom once the hearing starts, but would monitor the hearing from CCTV cameras as the hearings are generally recorded. If you have requested for an interpreter, rest assured, because the court will have arranged this at their own expense and the interpreter will be present on the day. If you have any doubts about needing an interpreter, better request one rather than chance it. You will be allowed to bring friends, family or any experts, and if they are to speak to the court they will need to be listed as witnesses prior to the hearing and provide statements. However, your witnesses will not initially be allowed into the court until after you have finished giving your evidence. The reason behind this is to ensure that each witness provides an impartial account, uninfluenced by what they have already heard. They will need to wait in the waiting area and will be called from in the courtroom. This adds to the quality of their evidence, because if they've heard the appellant give evidence and they just repeat it, then there's no reason for the judge to think that they're just not repeating what they've already heard. The hearing will take place in a courtroom presided over a judge of the first tier tribunal. You may be thinking wigs and gowns, but it is not the case, since it is much less formal. The judge will be dressed in a business clothes like suit, but they can be identified from where they sit, which is at an elevated bench looking down on the room. Before the hearing, all paper evidence must be submitted to the tribunal and should not be produced on the hearing day. Nothing will wind up a judge more than just producing a bundle of documents on the day, and it might not even be looked at. Most hearings are listed to start at 10 o'clock, but it's important that you get there at least half an hour early. This will enable you to meet your representative and hopefully relax a bit before the hearing. There is nothing worse than turning up late for your own immigration appeal. It shows you don't really care. You will know what time your case has been listed for by looking at the notice of hearing letter sent to you by the tribunal. As I say, make sure you're there early. You might not be heard at 10 o'clock, but the judge will decide the list and tell you when it's likely to be heard. One of the other reasons is that it's advisable to be there before the hearing time of 10 o'clock is there may be a need for a further conference if you just met your hearing. Plus every person's got to go through a metal detector and a security gate, and it can take up to 10 minutes to clear securance. So therefore turning up at 10 o'clock means you might not actually get into court till 10:15. It is vital to note that each judge normally hears several cases in one day. As they are all put down for the same time, it is likely your case may not actually start until later in the day. The judge will consider how many cases are listed for their courtroom, the number of witnesses involved, whether there are any interpreters or any special needs, and then make a decision on whose case is going to go first and the general batting order. What's going to happen at the start of the hearing? When the hearing is ready to start, the clerk will go and get the judge. You stand up when the judge comes in and sits down when the judge sits down. If it's a man, you refer to them as sir, and if it's a woman, you refer to them as madam. The judge may generally start talking to your lawyer in the Home Office, presenting officer, to ensure that everybody has the same documents. There's often a short discussion about what the case is about, the legal provisions relied upon either side, to try and narrow down the issues and make the hearing go smoother. The judge will then introduce themselves generally to you and explain how the proceeding will work. If you need to speak directly to the judge, you should address the judge, as I've mentioned, as sir or madam, depending on, obviously, on whether they're a man or a woman. However, it's best to address the judge if you've got any queries through your lawyer. Once, however, your lawyer and the presenting officer have confirmed with the judge that they're ready to start, the case will move on to the first stage, which is the most important. This will be your witness evidence. Lawyers call this examination in chief. What then is examination in chief? Prior to the hearing, you will have prepared a statement. If you've been instructed by me, then we will have gone through it in some detail. To begin with, your lawyer will approach you with this statement and ask you to adopt the statement. Sounds unusual, but it means that you don't have to repeat what's said. There will then be a few short questions to confirm your name, age, date of birth and familiarity with the statement. You'll be asked to confirm you've read it or you've had it read to you in a language that you understand, and it's your signature at the end of the document. Your statement is very important as it includes your story. It is your evidence that you're giving to the court. You will not be expected to stand up and read your statement aloud and speak at length about your case. Everything that needs to be said should be in the statement. If it is needed, and there are certain provisions, that your lawyer may ask the judge's permission to ask you a few supplementary questions, but that cannot be a complete retelling of your case. When your lawyer is finished, you will move on to the second phase of your evidence. This is cross-examination. This is often the most nerve-wracking part of the hearing, because this is when the Home Office presenting officer can and generally will ask you questions about your case or the documents you sent to the tribunal. Often, presenting officers will use this to try and test your credibility as a witness, to see how reliable or truthful you are by drawing attention to any inconsistent answers that you may have given at different times, hence the need for proper preparation. Therefore, it is foundational that you make the statement that is consistent with your account and you have read the statement. So you need to remember and go through the statement in great detail before the hearing and before you're interviewed. It can be useful to read the statement shortly before going into the hearing so it's fresh in your memory. It is critical that you answer all questions truthfully and honestly. It can be difficult, but please remain calm and polite. If you did not hear a question, you're perfectly entitled to politely ask the presenting officer or your own lawyer or the judge to repeat the question. If you did not understand the question, perhaps it was because it was a bad question. You're entitled to ask the question to be rephrased. It is your appeal. Do your best, know your statement, tell the truth, and this part will be over hopefully before you know it. Again, it comes down to the preparation, and I always place great weight on preparation in any particular appeal. Sometimes afterwards the judge may have some questions of their own. Don't be afraid of this. This shows that the judge is actually interested in your case and has listened to your evidence but wants to clarify a few matters. A tip that I would like to give you out of experience is to also speak loudly, clearly and slowly when answering questions, and look at the judge so the judge hears what you say. Another problem is sometimes people speak too fast. Sometimes I do it. But however, this is not good because the judge needs to write down what you have said. If you speak too quickly, the judge will stop you and this will interrupt the flow of your thoughts and up the flow of your evidence and can cause problems. Then there is a potential for what's called re-examination, and this means that once after the Home Office have asked you questions and the judge has asked you questions, your own lawyer can ask you some questions to clarify any particular issues that have arisen. Most of the time, re-examination is unnecessary, but it can be a valuable opportunity for your lawyer to clarify, as I say, any potential murky areas or inconsistencies in your cross-examination. Next, we'll turn to the examination of witnesses. If you have listed witnesses for the hearing, they will need to be led into court one at a time and will give evidence in the same manner that you did. Witnesses will not have heard what you have said during your evidence. This is important. So they may get asked similar questions by the presenting officer to test the truth of what has been said. It is vital, if you're an appellant, that you don't try and tell your witnesses or nudge your witnesses as to what to say. The judge will see it and will know there's something fishy. Sometimes the presenting officer will have no questions for witnesses. In that case, after the witness has adopted the statement, they will be invited to sit at the back of court and they can listen to the proceedings, or they can go home if they wish. If in the event your witness was not asked any questions, don't worry. It is generally a good thing, as it means that the presenting officer did not think that the Home Office's case would be helped by asking your witnesses questions. Often this is because they have provided a detailed statement which provides all the information that's needed. However, despite the length of the witness statement, it is vital for the witnesses to attend court, adopt their statements and be available to answer questions even if they aren't. It can be frustrating, but it shows that they're committed to the case and you're committed to the case. After that, that's the evidence. Then we move on to what's called closing submissions. Now, first of all, the presenting officer goes first and they will set out why you should lose and why your appeal should be dismissed. They will usually rely on the reasons for refusal letter and respondent's review. The Home Office, if you've made some mistakes in your evidence or the evidence is inconsistent, will also rely on any inconsistent comments that you've made. So it's important, again, to be prepared. Finally, your lawyer will get the final word by offering closing argument submissions setting out why your appeal should succeed. They will generally refer to the appeal skeleton argument, a document prepared earlier in the appeal process outlining the legal and factual arguments in favour of your appeal being allowed. Some judges are just content to hear the submissions and note them down. I generally go further than the skeleton argument and try and highlight positive points for my clients. Some judges, however, can be quite quiet and not say anything. Other judges, however, can be more involved and interventionist and may ask you or your lawyer questions during the submissions. That's not really a problem. After that, the judge will then signal the end of the hearing by thanking the parties. Sometimes the judge will speak to you directly and tell you how long it will take before a decision is made. The decision. Obviously, this is the most important thing. Now, a decision is in law not legally binding until it is promulgated, that is, issued by the tribunal. However, in rare cases, and they are quite rare cases, the judge may indicate at the end of the appeal that the appeal is going to be allowed, though that will not be binding until the actual decision is actually sent out to you. But more often than not, and I am saying more often than not, in more than 99 out of 100 cases, the judge will say, there's a lot of paperwork to be considered, I've heard a lot of evidence, I need to go away and think about it, and then I will give you my decision, which you ought to receive in 2 or 3 weeks' time. And generally you will receive the decision in 2 or 3 weeks' time. If, however, there is an excessive delay in getting the decision, then this can cause problems. It doesn't generally tend to happen nowadays, though I did have a case recently where the judge took over a year to make a decision and then made a terrible mess of the facts. And that just led to the appeal being reheard and the judge's decision being squashed. But this is very rare. You will generally receive it. If your case is on the new electronic system, it will be uploaded on the day it's made to your lawyer and they will communicate this to you. If it's on the old paper system, a copy will be sent to you and to your lawyer. After the appeal, there will be 14 days for either party to appeal. If you lose, you have 14 days to appeal. If you win, the Home Office have 14 days to appeal to the first tier tribunal. If the first tier tribunal think there's a problem with the decision, they will grant permission, and then there will be a further hearing in the upper tribunal to decide whether the decision is safe. If the first tier tribunal say no, there's no problem with the decision, again you can appeal, or the Home Office can appeal to the upper tribunal, and again the upper tribunal may say there is a problem or there isn't a problem. If the upper tribunal, if you win, and then the Home Office appeal and the first tier tribunal say no, and then the upper tribunal say no, then that will generally be the end of the matter, and you will have won your appeal. Again, I hope this video has been of some use as to what will actually take place during your appeal. Often I've had clients appear many years ago on the day of the hearing, and they quite frankly have no idea what to do. They're half an hour late, they haven't read the papers, it's not been prepared properly, and it's an absolute disaster. So the key is preparation, know what to expect, liaise with your lawyer, tell the truth, give your answers clearly, and do your best. And rely on the fact that the judges are impartial, they are not employed by the Home Office, and they will very often come to different decisions to that of the Home Office. I hope you've enjoyed this video. It's a bit out of the normal, but I thought it was about time I did one on what is often the most trying day in a migrant's life. I will of course be doing a video on what you can do to give your appeal the best possible chances of succeeding at a later date. Thank you again for watching. As I say, if you do have an immigration problem, do contact me. Do take care. This is Paul Turner, the Immigration Barrister at Imperium Chambers.